Hello, and welcome to Ipsa Dixit, a podcast on legal scholarship. I'm your host, Brian L. Fry, Spears Gilbert Associate Professor of Law at the University of Kentucky College of Law. My guest is Ed Timberlake, a former trademark examining attorney and copyright examiner who currently practices trademark and copyright law. We will discuss his article, #Trademarks Twitter Addresses a Gap in the Literature, which was published in the Idaho Law Review. So, welcome to the podcast.
Thanks very much for having me.
Yeah, my pleasure. So as you know, I am a big fan of your work in the trademark sphere, and I like to say I've probably learned as much about trademarks from you as anyone else. So thanks first to begin with. And it's a real pleasure to have you on the show. And because I'm so happy to have you here, I really want to kind of start from square one in this kind of conversation about trademarks and trademark law. So maybe you could, for listeners who may not be kind of conceptually that familiar with trademarks and how they work, just kind of talk a little bit about what a trademark is and how a trademark is created.
Okay. So not to sound ungenerous, be an ungracious guest on your own show, but I think maybe what trademark is might be the wrong question in the case of trademarks. It seems to me the core of what trademarks, to understand trademarks is to kind of open up the question of what they do, that they're doing this thing. And the doing, the action of it, the trademark action is really where all the interest is. You can sort of stick almost anything into the slot of something that's working as a trademark, and so the sort of insight, I think, is just that this is a cognitive thing that's going on. This is a connection that's happening. Sort of almost, if you think of it in terms of like a stimulus and a response sort of thing, where it almost doesn't matter what the stimulus is, but we're trying to find, a particular response. So to sort of oversimplify it, what the law recognizes is symbols. Some kind of symbol. So something that can take on a particular meaning. And of course, the way that the human brain works, just about anything can be imbued with meaning. Anything that you can perceive can be imbued with meaning. But the story that we tell about it, at least, is that when people will see this thing in connection with a particular product, and they'll know that's coming from a particular source, is what we say. That's sort of, I don't know how accurate, that really necessarily is, but it's a helpful way to frame it, is that you see a thing, and hopefully you like it, but kind of the requirement is you have to be able to perceive it. It has to be able to be like different enough that it can play that role. It can't just be sort of like, if you think about the case of like ringing a bell and salivating, not to compare to consumers here to dogs in this experiment, but if you have a ringing bell and a response, then the bell you need to be able to perceive the bell, and it needs to be able to stand out from the background noise. It needs to be different enough. So that's really sort of the action of it, is something that if from a business standpoint, if you're saying, all right, well, this is an opportunity to get something in front of consumers and have them make the connection with me, with my stuff, my goods or services, or whatever it is that you're doing. So it sounds sort of esoteric, but I think cognitively it's the kind of thing that we're doing all day anyway, that human beings are constantly walking into situations, scanning for things that we can detect, and having, shorthand sort of responses based on those things that we're detecting. So it's sort of, I would just see it as a subset of something our brain is doing constantly anyway. This is just in the commercial context.
Right. I like that. It's like trademarks are as trademarks do. So I think a lot of people kind of have come to think of trademarks in relation to what the government does in some ways. So I wonder if you could help kind of clarify the role of the government and of the Trademark Office in relation to this kind of more person-centered, experiential kind of quality of trademarks. It's like sort of what's the purpose of trademark registration, and sort of what role does the Trademark Office play in relation to the quote unquote creation of a trademark?
Yeah, so I think, I mean, at least as I see it, trademark stuff, trademark, that kind of connection, that cognitive connection, is happening anyway, and it's happening, probably a form of it is happening without governments, without a Lanham Act, without, particular statutes. I think we can look back and see how even pre-literate societies have had some sort of designation thing, and even without a court system and without registration, they have ways of marking sort of this comes from a particular group, or if you're in a particular tribe, or this kind of connection. So it's that part is going on anyway. I think if you think about the government's role is overlaid on top of that. The government isn't creating trademarks. The government isn't. I think sometimes people have who haven't gone through the process have a notion of like, well, I've got to go to the Trademark Office to get a trademark, and that's not what you're doing. That's not what the Trademark Office is doing. It's of course completely confounded, or the situation is confused by the fact that it's the U.S. for no good reason. It's the U.S. Patent and Trademark Office, and on the patent side, you do go to the patent side for a patent. You don't have a patent until you go to the patent side and they give you one. That's not the case on the trademark side. On the trademark side, what they're doing is they register, they provide registration. Registration comes with all these great benefits, but they can't register your trademark unless you can show that you have a trademark already. I mean, the process doesn't work that way. So my sort of view of, we've had registration in the U.S. for a while, but for me, the most interesting part, the modern registration portion comes about with the Lanham Act. And my view of what the Lanham Act is doing, sort of very high level view, is that it's saying, all right, there are trademarks already in the world, and there are trademarks that people will be using. And even there is already a mechanism for dealing with trademark disputes. To my mind, the Lanham Act comes along and says, all right, given that as the base, what are we going to add on top of that? And so the rationale seems to me to say, look, you can already use trademarks. You can already create these trademark meanings. We're going to offer kind of this benefit. We're going to dangle out these legal, sort of tilt things legally in your favor. And what you've got to bring to the table is to make yourself stand out more than you otherwise would. Which is so there are certain things that if you bring to the Trademark Office, they'll say, well, we're not, this is kind of below the bar of what we're going to be able to register, so you don't get a registration. So it seems to me the goal, the kind of impetus is, if you're at the stage of starting to try to create this trademark connection, the Lanham Act wants you to be more different than the other things out in your market. And if you do that, then you get all these great presumptions.
So maybe we could dig a little bit more into that particular moment. So like, how does the Trademark Office, or maybe even like, how does a trademark examiner decide whether or not a registration application is one that they should approve or reject?
Yeah, so the statute is great. I mean, the statute just kind of lays it out. The first requirement really is that the statute says, look, if it's distinctive, your thing's got to stand out. So if you bring, sort of the oversimplification of this is, if you bring a distinctive mark to the Trademark Office, then the statute says they'll register it unless a number of these sort of, specific situations, and the situations get sort of like weirdly specific sometimes. So there are a couple of things, but the general rule is if you're distinctive, you're in. And in this context, distinctive means that, there's reason to believe that consumers could see this thing, they can perceive it. It's not like invisible or inaudible or whatever. They're able to perceive it, and this looks like the kind of thing that's going to stand out from the background noise. It's going to be different enough for them to recognize it, and sort of the central portion, to my mind, of examination is the proof, is the evidence stage. And so you don't just say, hey, we've got this symbol and we've got this stuff. It really kind of, the action really starts when you're sending in evidence to say, look, this is how we're using it. This is how people are going to encounter it. So there are, and that's a major part of the decision hinges on what the evidence like. Basically, like any other sort of legal proceedings, like you're opening up the evidence and just saying, okay, is there enough here? How persuasive is this evidence? So, for instance, and I forget who did it, but the examination, like if you basically take exactly the same symbol and stick it in various places on a product, or if in a different font, if you use it differently, basically if your evidence is different, you can have more or less persuasive evidence for the very same sort of combination of letters, depending on how you use it. So a big part of the examination process was just getting right to, there's the sort of the administrative side of like, okay, do we have everybody's name and is the address correct? But the real action, I think, was looking at the evidence of how it was being used. And of course you can't, given the volume and given the way the statute is written, as an examiner, it's not like I'm calling up consumers and saying, hey, do you think that this really stands out? And I'm not going to, out into public and giving people surveys like, do you get the connection here? So it really is, you're looking at the evidence, but you're still having to kind of guess. I don't think that's a flaw in the registration system. I think that's part of the benefit. I think that's why the registration, the filing fee is $225, not $20,000. Is that you're getting a very educated guess, a very well informed guess, but we're having to look at the evidence and say, is this the kind of thing where we think that this will stand out enough? And you get better over. It helps. What's the numbers, like you do something once and it's kind of hard, you do it 10,000 times and you're like you learn a little bit about it. And so the office has done it way more than 10,000 times, and they develop a lot of institutional knowledge for being able to assess whether it looks like consumers will make that connection.
Yeah. Okay. So this leads into a question I'm interested in how you respond to. So the law is a very dispute-centered sort of field, right? And so as scholars and as lawyers, I feel like we tend to sort of look to disputes in order to understand what we're doing in a particular area. But you argue that we should do something a little different, right? So why do you think that scholars and practitioners should study trademark applications and registrations rather than just trademark litigation? Like, what can we learn from the registration process that litigation can't teach us all by itself?
Well, it seems to me that even if you're a big fan of litigation, even if you're coming to this from sort of a dispute mindset, which, by the way, I would sort of characterize as, particularly in the trademark area, is the idea of looking at trademarks primarily in terms of disputes seems to me kind of analogous to, if we were training doctors only to look at illnesses, or more to the point, only to focus their attention on really expensive, medical interventions, as opposed to health, which I guess you could argue we kind of do, but it doesn't. I don't think that strikes anybody as a great system. So it seems to me that we, professionally as lawyers, we have an obligation to focus more on the health side if we can, rather than just waiting for the expensive interventions. But even if you're a fan of litigation, even if disputes are where you're at, we got a lot more data in the filing area. There are. I know it seems like there are a steady flow of cases, but there are relatively few cases, court cases, compared to the thousands, hundreds of thousands, millions of records of how things have been assessed at the Trademark Office. And not to begrudge any, I recognize that federal judges have an awful lot to deal with, but I'm guessing that if in the usual situation with a federal judge is that they will handle relatively few trademark matters in the course of their entire career. I mean, I think in a month, an examiner at the trademark examining attorney at the Trademark Office will probably go through more juicy, difficult, complicated trademark analysis and different variations on this same kind of situation than a federal judge would probably do in a lifetime. So even if you're looking for dispute material, it seems like it's an oversight that there's this gigantic database of examples. Now, I recognize that the sort of the normal approach, and at least the law school way of sort of designating this is, okay, well, any one examination decision isn't strictly speaking precedential in the way that we think in a court case. And sure, that's fine, but 100,000 decisions start to carry some weight, and I think it seems to me like we just haven't. This is kind of it's a giant resource that seems to me largely untapped, and to dig into that, and you can give you, I think, a broader sense of the trends. Because also the court cases, they're just so few and far between on given matters. We'll have one or two big cases on a particular subject, and then if that's the precedent, it kind of sits there and you're like, all right, we've got these one or two things, and they're always complicated by some other factual matter in the case, like the parties already hated each other, or the parties had a license and then had a falling out. So you don't really get as clean an assessment sometimes by how the court case comes out as you would from a gigantic data set of registration decisions.
Yeah, I mean, talking to you, it really strikes me that so much of the sort of institutional knowledge of the Trademark Office in asking these questions about how trademark meaning happens is bound up in these heuristics of the people who sort of end up doing the decision-making process at the Trademark Office. And then there's such this, as you say, like this incredibly copious database of material, because the Trademark Office just provides vast amounts of data about what it's doing and how it's doing it, and evidence of what has happened and what it was looking at and all this kind of stuff. But in a weird way, I feel like those heuristics are almost kind of bound up in the interstices of the registration decision-making process, as it were. I mean, like, do you have a sense of how we can look at that data and think about or understand how the people who make the decisions are thinking when they make those decisions?
So I think the first too simple way of maybe characterizing this is that it doesn't, to my mind, well, first off, I just find the records fascinating. Life goal is to look at every single thing that's filed in the office for any matter ever. Because I find it naturally interesting, and I think there's a lot that we can learn from it. But it doesn't seem like the kind of thing that's conducive to a spreadsheet. I mean, I don't think we can pull out this total numbers, or even like this is what goes in the mark field and this is what goes in the identification of goods field. It doesn't. I mean, it seems to me like the material is too rich, really, for that. It seems to me that there's a lot that we can learn by going one by one. And frankly, for somebody, if you had never been inside the office, there's a lot that's kind of between the lines. And I don't think that's necessarily by design. It's not like anybody's trying to hide anything. It's just you're in a big hurry. I mean, you got thousands of these things coming in a day. So just opening them up. I mean, I'm constantly surrounded. I've been doing this for a long time, and I've been attending to these filings for a lot of these filings, and I'm constantly surprised at things that I find in there. So I think until you've looked at a lot of them, I think it would seem kind of baffling. And until you've looked at an awful lot of them, I think it could easily seem, it'd be hard to find the pattern, hard to find the consistency. It might look on a surface level like there's a lot of inconsistency. And I know that's thrown around as a charge fairly often, that the examination decisions themselves can be inconsistent. Although I'm a little touchy on that subject in that usually the proof that's offered for inconsistent examination decisions is not very foolproof. It tends to, I don't see people getting a really close examination of a lot of specimens when they're talking about this. And specimens are really kind of the name of the game, as far as I'm concerned. That's where the action is. That's the real evidence. So until you open them up and look at a lot of them, I don't know that it would be that easy to get a sense of what's going on. But I will also say that that's part of the value, I think, of having folks who go there. And when I started there you kind of had two groups. You had people who'd been there less than 2 years and people who'd been there, more than 15 years. And so there were an awful lot of folks at the office who've been there a really long time and been looking at a lot of this. And I think you get better decisions. I think individuals are able to do this with a deeper understanding over time, and certainly able to probably do it faster after having done it for quite a few years.
Yeah. Well, so this leads into another question or something I'd like you to reflect on, which is that, as kind of a lawyer and legal scholar for a number of years now, it always struck me, that the law is such a kind of logocentric profession. I mean, like, I'm reminded of like the philosopher Austin, so like the law is like an entire life lesson in how to do things with words, as it were. And there's been kind of an empirical turn in legal scholarship, but that seems to end up being sort of how to do things with numbers, right? But what we're missing is images and sort of perceptual experience there. And I wonder if you could talk a little bit about like sort of why images are important to thinking about trademark, why we should be concerned about the specimen or the proof or the example. Sort of how does that help us better understand what's going on?
Well, I think it's natural enough, but I believe it seems like there's a tendency, law school is very wordy. I mean, I think the people coming into law school tend to already have sort of, oftentimes already be leaning in the verbal direction. And then, I don't remember a lot of great visuals from law school from the entire time. So I think if you weren't that way before law school, you are likely to graduate from law school very, very focused on the word part, and maybe to a certain extent uncomfortable with visuals. And so we just, if for no other reason than just giving people some practice of how to look, and like actively look, not just like, well, look at it, but like, okay, let's, reading. We get plenty of practice reading text, but I don't know that we get a whole lot of exposure to reading images and sort of looking for what's going on in images and looking for not only the meaning that can be there, but like how that meaning is created. So I think we tend to be a group of people focused a lot on just the verbal aspect, but trademarks don't care about that. Trademarks they existed before registration, and it seems to me that the sort of on a certain level, trademarks recognize the way that they've been used out in the world. Recognize that the goal here is the attention. The goal isn't to fill in a particular line and say, well, you have to put a word here. It's like, we don't care about that. We'll be a color, we'll be a shape, we'll be a sound, we'll be whatever it is that we need to do in this given situation to get attention, more attention than the competitor right next to us. And that, I think that's good. I think that's exactly what trademarks are doing. So I feel like we kind of need to, I feel like in the law space, we're maybe not meeting trademarks kind of where they're at if we're starting so far over in the verbal aspect, and we're just not, and we're not used to looking at images, and even to the extent of like, if you've got a trademark that exists in 3 dimensions, lawyer-wise, we have almost no training in just like the basics of how do I describe this part, you know, the upper part from the lower part from the back. I mean, we're so the more that we can look at images, the more that we can read, sort of practice reading images, I think we will do better trademark work, because trademarks don't care about us being limited to the verbal space.
So in your paper, you talk about Twitter and the Twitterverse as sort of a forum for studying and thinking about trademarks. How do you think Twitter as a medium can facilitate and maybe encourage this sort of systematic study of trademarks as images and make our kind of perspective a little bit less logocentric?
So I think sometimes some of the criticisms of the format of the Twitter, sort of the limitations of it are put out as like, well, how much of a conversation can you really have in that space? Isn't this sort of like diminishing? You know, can you get into big subjects? To me, it seems actually a strength of Twitter, the fact that you've got a relatively small amount of space, and I guess on a practical level, to a certain extent, I think it was probably cheating early on Twitter, when I realized, okay, well, this is actually before on the lower character count. Like, all right, well, I don't have a lot of characters here, but I got free images. I can put as many images in here as I want. So I think that the fact that when it comes through on the feed that the image is already there, seems to me like an opportunity to say, look, there are a million things getting filed all the time. A lot of them have really interesting stuff going on. And if you can get that, if it's got a visual aspect to it, the opportunity to get that in front of a bunch of people who, you know, I mean, I had no reason to believe anybody would be interested in looking at these things, but it also wasn't costing me anything. I was looking at them anyway. So the idea of just saying, hey, I think this is kind of interesting, and you can show the actual full-on image. You can say a little bit about it. You don't have a long space, but I think that's sort of a strength in some ways, because the last thing, I don't really understand Facebook, so I don't really want to criticize anybody, but the idea to me of starting into an utterance, like not knowing how long it's going to go, like I don't find that particularly appealing. In the Twitter context, the sort of feed aspect of like, isn't this interesting? And if you don't think it's interesting, you just move on. But if you do think it's interesting, then there can be a little bit of words, you can see it. And the giant benefit, I think, of linking straight is sort of like, I consider it a great opportunity, the fact that you can link straight to the record. So you don't have to listen to me say almost anything about it. And you don't even have to necessarily listen to me say, isn't this interesting, or you should find this interesting. It's like, just look at it. If you see it and it seems interesting, you can go straight to the record, and all of the data is there, and we're all working from the same from the same material. And then from there, it seems like we're in a great place, that we're already connected. We already have accounts. So if that strikes you as interesting in any way, we can immediately start conversing about it. And that just, the combination of those things, and the fact that you can get the images first, I think is a giant strength of the format.
Yeah, so I wonder if you could talk a little bit as well about like the role of repetition and seriality in studying trademarks, because you've kind of alluded to that a little bit already, but like sort of how does Twitter perhaps sort of facilitate or encourage that sort of shift or turn in thinking about trademark law?
So that probably, it'd be easy for me to imagine that coming from having been an examiner where you just have an infinite feed of new filings that will never stop. So maybe Twitter seemed familiar to me in that way. And also, I think because of what trademarks are doing, because trademarks are saying, look, you've got this raw material, and do these circumstances look like they're the kind of circumstances that would give rise to meaning? You know, is this the kind of thing where consumers are likely to create meaning in this space? It seems to me like you just have to do that over and over and over and over. I mean, in some cases it's a pretty tricky analysis, and in a lot of cases, you know, some of the fun cases, particularly fun cases, it's also unfamiliar territory. Like, I don't know what this market is, and I don't exactly know what they're trying to do here visually. So you don't get it right at first blush. So it seems to me that really the way to do it is to do it over and over and over and over and over. And the ability on Twitter to be able to do that for free and to do it instantly and to have the visuals right in front of you so that you can be like, oh, well, now I've seen 5 things that are kind of in this space. And I get how people in that, you know, the relevant consumers would be creating meaning there. Because I think there's a tendency to say, well, that doesn't mean anything to me, so therefore, no, it must not be functioning as a trademark because I'm not making any cognitive connection. One of the sort of repeated things that you had to keep in mind as an examiner is just that we're not necessarily the relevant consumer. We're not necessarily, you know, that maybe I've never been a person in that market looking to buy one of these things. And so I routinely still see things where I'm like, what's going on here? And then you look at the market and you're like, oh, well, they would be selling, you know, this would be meaningful. Sort of like an example or an analogy might be like musicians, you know, that like, I don't play guitar, but people who play guitar know guitars. And within a group of people who were goofy about guitars, they would recognize certain things as being meaningful that I wouldn't necessarily recognize. And you see that kind of thing repeated all through the different filings and registrations where you realize, oh, for the person who's in the market for this thing, for the relevant consumer in this case, this aspect or this curve or this color or this combination of, you know, whatever the stimulus is, would give rise to meaning. I just think that until you do that a lot, it's really hard to get your head around it.
So, Ed, in closing, I wonder if you could reflect on how thinking about trademarks from the registration perspective and from the kind of experiential data perspective almost might help students who are interested in trademarks and interested in potentially practicing trademarks sort of think about how they can provide better and more useful services to their clients. In other words, how can thinking about trademarks in this way help students and maybe lawyers become better advisors for clients who need to understand what's happening and, you know, sort of how to make their trademarks better and more useful to their business?
I think first that trademarks, the subject, whether you're, and the general subject of trademarks, I think that's part of the appeal to me of situating this in the legal space is that we could just be talking about all trademarks, but that's almost too big a subject. So if you limit it down to, okay, well, if our focus is really going to be registrations and the process of registration, that subject is just a lot more interesting than people maybe realize. And it's a lot more interesting than the cases make it sound. I mean, the cases, I'm afraid, tend to give the impression that what we're doing in this space is you know, one big company with not a particularly distinctive mark is suing another big company with also not a particularly distinctive mark, and losing and then appealing. You know, and it's like that to me. That's an aspect of it, I guess, but that's not. Businesses aren't in the business of filing appeals. I mean, that generally, it's hard to get a lot of value in every case. It's hard to argue that in every case, the amount of money you spend on that kind of legal effort immediately comes back in value to your business. So first off, it's just more interesting than the cases might suggest. And secondly, I think that if you sort of orient what's going on as that connection, that cognitive connection, or the creation of meaning in consumers' minds, then instead of jumping immediately to sort of the negativity of like where are we going to sue, or is this infringement? If we say, well, all right, if the Lanham Act is trying to get us to be more distinct, the Lanham Act wants us to stand out more, then that starts at the very beginning of the process. And if you're lucky enough to be practicing in this space and have a business come to you before they're already doing something, it seems to me that with this orienting the subject this way is an opportunity to say, look, rather than sort of, is I think also a fairly standard scenario, essentially ends up raising the question of like, well, how close to this other thing can we get? It seems to me that we provide a lot better value to businesses if we kind of reorient it as at least starting the conversation rather than how close can we get. It's like, how far away can we get from something? How more different can we be and still have it work for us? And still have it be kind of manageable. And I've lately sort of started to wonder if, and maybe this is getting a little far afield, but whether there's also like a little bit the way the system in practice works now, where there's a little bit of a social justice sort of element to it as well, because it seems like by framing it as a very dispute-oriented area, you kind of price a lot of people out of that game, whereas for essentially for free, you can encourage somebody to just go in a very different direction. So like if you're starting a business and you've got a very small business and you don't have any money to appeal a ruling in the first place, then maybe by making from the outset going in a more different direction, and as the lawyer, if you can guide a little bit of that to sort of say, look, if we go over here in a very different space where there isn't anybody else, then not only will that be an easier registration decision, but there isn't anybody over there. We're less likely to bump into people who are going to say, no, you're too close to us, because we're way out on our own.
Awesome. Well, Ed, thank you so much. This was like a great conversation. And as always, I learned a ton from you about trademarks, how they work, and how to think about them more productively.
Well, you're very kind. Is it time to play the pump organ?
Here's the bangs from Now Magazine. Came out the other day.